Great having you here. We're going to answer every question now that's been submitted. First question, for the director's president position, is there a document that might address the actual powers of the president and limit those powers? Require more than the president's signature on contracts or purchase orders? Okay, so great question. So if you're serving as your president, or if you're concerned about, the liberties that maybe your president is taking, a few things to look at. Number one, we shared with you our cheat sheet on duties and responsibilities of board members. On the flip side of that cheat sheet, we talk about what is the typical role of the president. That's a good resource. Second place you should be looking is your association's bylaws. The officers section in the bylaws will outline the responsibilities and the roles of the president. In addition, you also want to look at how much authority has the board given the president. And by that, I mean, look at the minutes. In some cases, the board will, look at what the president, maybe the president's the only person that's there during the summer months. And so maybe they'll say that the president has the authority to approve contracts up to $5,000, or the president has the approval to sign contracts on behalf of the board if a majority of the board approves it. So there's three places that you really want to look. So is there a document? Yes, the bylaws is one place. You also should look at the minutes and any resolutions that may have given the director, the board president, more power. Okay, I went a little bit out of order on the questions, so I don't want to mix anybody up. So the next question is, what documents do we need to request from our current HOA management company to verify the last recorded annual meeting and when the next annual meeting is scheduled for the community? Okay, this is a really timely question because during COVID, some associations missed their annual meeting in 2000, and maybe I have a couple that missed it in 2021 too. So remember, you have to have an annual meeting every year. So what documents should you look at? Number one, look at your bylaws, because the bylaws will tell us when should your annual meeting be. Sometimes it gives a month, sometimes it gives a week within a month. Other times it just says that the board has to have it during that fiscal year. So look at your bylaws first. And then second, I would ask for copies of all previous annual meetings, whether they've been approved or unapproved, just to see if there's a general, has this been handled always in March every year or whatever. And so I would ask the management company for that. I would go to board meetings and ask, when are we planning to have our annual meeting this year? And I think those are some good tips for you if you want to find out more about when your last annual meetings were. Remember that you approve the prior year's annual meeting minutes in the current year. So for example, in your 2022 annual meeting, you'll be approving the 2021 annual meeting minutes. So it's possible that the management company may say, we don't have those approved yet for 2021, so you can't have them. What you could do is just ask for the unapproved version. Maybe they'll give those to you. But that's the information that you need to ask for to find out when your next annual meeting is. Next question. To date, I have not received any notice on the status of the vote. I did call the Maricopa Recorder's Office twice and they had no record. They advised me to ask my HOA. At the end of 2021, I sent a letter to our management company and they did not respond. How can I find out if our CC&Rs have been recorded within 30 days of our vote being completed? Okay, so great question. So apparently your association has just gone through a CC&R amendment procedure. Once the association receives the requisite vote to, pass the amendment or amendments, the association under the Condo Act and Planned Communities Act has 30 days to record the document. Typically, the document is signed by the president and the secretary and notarized. Their signatures are notarized. If the management company doesn't provide you with a copy of it, you could reach out to the association's attorney who helped the association with it and ask to have a copy of it. You can make a records request through the association's attorney or the management company. You also, if you're familiar with the Maricopa County Recorder's website, you can, Google Maricopa County Recorder, go into their website, do a search based upon the association's name, limit the search to within the past year to see what's been recorded in the past year, and it should pop up. So I hope that's helpful for you to find out if that information has been recorded. Okay, next question. If an HOA's bylaws allow non-director HOA members other than the president to be selected as officers, such as for the position of treasurer, is it wise to select a non-director as treasurer? And if so, what might the ramifications be? So great question. Sometimes we'll see in older association bylaws that non-owners can serve as an officer for a corporation, specifically an HOA or condo. And so I'm guessing that's what you mean by non-director HOA members. Maybe they're members of the HOA. Maybe they're not even members of the association. It doesn't really matter. We analyze it both ways. So you want to check to make sure that, okay, do the bylaws allow for this? If they do, it's allowable. It's really not advisable though. Where we've seen this, in documents is when the developer is in control, they typically have the developer's team serving as the board, and the team may not actually own property. And so they have the bylaws state that you don't have to be a director, or an owner to serve on your board. It's highly unusual that a non-owner or a non-board member serve as an officer like the treasurer, and I don't really advise it. The only time I can see maybe you might want to do that is if somebody is like a CPA and they're willing to serve as a treasurer, but it's kind of not that smart for that person to do that because we want to make sure that they have coverage under the insurance policy, and really just best practices would be to have the all directors and officers, be members of the association and be directors. And if you want to get in somebody with specialized expertise, like a CPA, you hire them to give advice to your association. Next question. If I remember correctly, homeowners can ask to see the results of a board election or a ballot measure. If that is correct, it is. You are right on that. If a board member asks about how another homeowner voted, can we tell them, or does that break confidentiality? So the question is, can owners request to see ballots for a board election or a ballot measure? Maybe you're doing a special assessment or amending your CC&R or something like that. Yes, the owners can see that for sure. There are some requirements, like the records only have to be kept for a year by the association, so you should make that request within a year. And that's a book and record of the association. So owners should be allowed to review that and see how people voted if they so choose. The only exception to that would be is if it's a secret ballot where the ballots aren't going to have any indicator as to how a person voted. There would be no way for them to tell how somebody voted. So, we wouldn't be able to track that and tell them if a secret ballot was used in an election or on a ballot measure. So, next question is, we have an HOA website that is hosted by a paid service that requires checking a lengthy terms of use before posting content to a hosted webpage. For example, a suggestion box webpage that is only accessible by the registered HOA members to sign in with a username and password and then post content to it. Is this sufficient to protect the person that created the suggestion box webpage from liability for suggestions posted by other owners? Okay, so you have a website, paid service, requires lengthy terms of use, checking a lengthy terms of use. Okay, so the homeowners have to check this box saying that they agree to the terms of use before they host content for a web page. I don't have a problem with that. I'd have to see what the terms of use say, but I'm guessing that they're reasonable, but I'd have to see the terms of use before I would give a blanket yes, it's okay for them to sign it. And again, it's a service that you're providing, and as long as the terms of use are reasonable, I have no issue with you, having the HOA website require that the owners check this box after they've read it and agree to the terms, as long as those terms are reasonable and consistent, with what other websites would have, in terms of what owners can and can't do there. Next question, we're on question 7. We are a self-managed association, so we are responsible for paying our own bills. Is it legal or advisable to use the bill pay function on our account? This is the way many people pay personal bills. We were wondering if this is an option for us. So great question. We have a cheat sheet we're just sharing with you right now on the basics for self-managed associations, which has some great info for you on this topic and other topics. But the bottom line is I'm okay, totally okay with using the bill pay function. Many associations are using that now, just like we use it in our personal life. But whoever is the treasurer needs to be reviewing those bills, even if they're automatically being paid. And so either they're clicking a box to pay it electronically, or they are reviewing it after it's automatically processed to make sure that the bill is reasonable, or there's no, outlier results, like the water bill didn't triple in 1 month. I mean, because typically that means that there's a water leak somewhere. So you can't just put it on autopilot and never look at it again. The treasurer would definitely have a responsibility to look at that. Okay, next question. We're in the process of our annual election. Could you comment on Arizona Statute 33-1250? Our property manager has been separating the owner identification from the actual votes on the ballot before counting. Is that legal? Seems contrary to what the statute above says. Our local bylaws do not allow for secret ballots. So I have to click on that actual link to, let's see if I can do that real quickly. So I'm not sure specifically which section you're referring to, but this section 33-1250 pertains to, what absentee ballot language must contain. From my perspective, it is odd that the property manager is separating the owner identification from the votes on the ballot before counting. You only do that if it's a secret ballot. And so it's just odd. I don't know if they're cutting them with the scissors or what, but that seems problematic to me. So I would, the board should be commenting on that. The board should be giving direction to the manager saying, these ballots are official records of the association. We shouldn't be, separating the name from the vote unless there's a legitimate reason or unless we've announced it's secret ballot's going to be used. So I think that's odd. That raises concern to me. So I would definitely check with your board. If you're serving on your board, you should just give direction to the management company, stop doing this. Okay, next question we have is, let's see here. I'm an insurance agent. Just getting into writing HOA policies. What are the most common coverages that insurance agents miss on the HOA insurance policies? Okay, so thank you for being here today. I'm already loving that you care so much about our industry, that you're getting involved in this. What I would recommend that you do is look at our cheat sheet on insurance. And we've already shared it once here today, and you can find it on our website at mulcahylawfirm.com. And that outlines the different insurance policies that associations typically, get for their association. Some newer ones that we've kind of been hearing more about is like cybersecurity, that we, are kind of a newer issues that might not yet be on that cheat sheet. I don't know a lot of associations that actually are carrying that right now. It might be a rider already on your current policy. But what I would recommend is that you look at our cheat sheet on insurance coverages for associations. When you're helping an association determine what type of insurance they should be carrying, make sure you look at the CC&Rs, because the CC&Rs will outline the specific requirements, especially for condominiums, in terms of how much coverage they're required to have, so that you're making sure that you're selling them a policy that is consistent with what they're required to have under their documents. Okay, question number 10. Homeowner altercation resulted in damaged property. Homeowner 1 was using oils and a tool and a massage tool in the jacuzzi. Another homeowner, number 2, confronted this homeowner. Eventually, things escalated, and homeowner 1's cell phone landed in the jacuzzi. Ooh, this doesn't sound good. Police were called and a report was filed. Signs are posted all over the pool and jacuzzi area. Please do not use oils. Question: after reasonable notice of the violation from the HOA, if it does happen again, Can we ban homeowner one from using the jacuzzi for violating the pool rules? Will there be any unforeseen legal ramifications for doing so? Great question. Your pool rules should have specific, specifically address this. And so it sounds to me like there's signs already posted at your pool saying, no oils are to be used. The association can, fine this owner for that behavior after giving notice and an opportunity to be heard, as long as, there's eyewitness testimony that this actually happened. Can we ban this person from using the jacuzzi because they're in violation? I'd have to look at what the CC&Rs say and also the bylaws in terms of whether we can limit somebody's ability to use the common areas for violations if they're not in good standing. This is kind of a tricky one. I, I would say my inclination is no, because every owner has a right to use the common areas. But if they continue to violate it and use oils that are damaging, I think that we could likely have the attorney send a letter telling them to cease and desist. And if they continue to do it in the future, we could fine them large fine amounts, or maybe even, tell them they can't use it anymore. Although it's really hard to do that because there has to be somebody there, like a security guard there who's monitoring the pool, because these people just sneak in and use it. And, I'm not sure that just a letter from the association saying you've lost your privileges to use it, and there are questions as to how long this would be for. So it's kind of a sticky wicket. I would recommend fining the owner. I would recommend escalating it to your attorney. And if they continue to do it, you may have to get a court order telling them to stop doing it. Okay, question 12. Let's see. Our HOA board, of which I am a member of the board, wants all of the board members to sign a code of conduct. I've consulted another lawyer about this code. His response was, in general, the language used is broad, imprecise, and not particularly well written. And some of the items violate your First Amendment rights of free speech. Item 5 is trying to limit behavior even when you're not a board member. And the attorney's general consensus was that this was overly broad. How can I challenge this? Okay, a couple things on a code of conduct. We actually have a cheat sheet on this, and I do recommend having associations adopt a code of conduct if there's a high level of dysfunction in the community on your board, because it shows, I see all the warning signs, like people aren't following the documents, they're not respecting fiduciary responsibilities to the community, they're not keeping confidential information confidential. There's a number of reasons that would prompt me to say you need to adopt a code of conduct. Maybe your association's board is thinking that already, and that's why this code of conduct has come into play. Take a look at our cheat sheet on the code of conduct. I don't think ours is overly broad. What you might want to do is recommend that your board consider adopting our cheat sheet language on the code of conduct, because I think it's fair and even. I can't comment on that other one because I haven't seen it. But I'm not opposed to codes of conduct where there's a high level of dysfunction on a board. Sometimes it's necessary because things are out of control. We need to get things dialed back in so that we're focusing on improving our community and we stop fighting as a board. And so I'm not opposed to it. What you might want to do is look at our code of conduct and see if the language is more suitable there. Just a note, a word of caution for you. A majority of the board can adopt the code of conduct. So you can vote against it and the board could still subject you to it. So you do need to know that. So, be careful that you aren't violating it if in fact it has been adopted by your board. Next question. What does a homeowner do if they know that a board member has committed unethical, if not fraudulent acts, and another board member is covering up to avoid scandal or accountability? Okay, this is a tough question because I don't know how serious, it sounds kind of bad, ethical, unethical, possibly fraudulent. Well, I think you have a right as a homeowner to make a records request. We talked about that today. So I would request records on whatever you think the impropriety is going on. You could go to the ADRE, the Arizona Department of Real Estate, and file a petition against the board members regarding whatever improprieties you think might be occurring. That is kind of at a minimal fee of $500 per claim. And there's no liability for attorney's fees. So that's something that you can do. You can run for the board yourself. You can do a removal petition to remove your board from office, and you can find the procedure on that on our top 10 cheat sheet, number 6. There's a state law that applies to removing a director from office. These are all, options that you have. I'm sorry this is happening to your association. I don't know for sure if there is a cover up or whatever, but I think I'm giving you the tools to find out more information. Okay, question 13. Does ARS Section 28873, effective September 2021, regarding sidewalk encroachment for ADA accessibility, apply to common area sidewalks? Our internal roads are not public. Actually, I'm not familiar with this statute, so it's hard for me to comment on it specifically. But typically, if your internal roads and sidewalks are private, if something that applies to public streets and public sidewalks wouldn't apply. Okay, next question, number 14. If we didn't meet quorum for our annual meeting, what happens to the member that did not run again? Do we then only have 4 out of the 5 members? So really good question. So we're trying to have an annual meeting. We didn't have a quorum. And so the election didn't take place. So what do we do with that holdover? So one board member was running for election. One seat was open, excuse me, under your facts. So we have 5-member board. Apparently one seat was open for the election at the annual meeting. So what happens, unfortunately, is for the member that chose not to run again, they stay on the board seated until their replacement is elected. Typically, that's how bylaws are worded. And so even though that person didn't want to run again, they're still on the board. So what that person, you have to decide, are we going to try to have a second attempt at the annual meeting? If so, that person just stays on until the next attempt at the, reattempted annual meeting to get a quorum. If your board decides you're not going to reattempt to have the annual meeting, some options would be that board member stays on until the next annual meeting in 2023. Another option would be for that board member to resign in writing. And typically when there's a resignation, the board can appoint the replacement. So the board could appoint the replacement, during this year. And then you'll want to check to see how long that replacement's term is. Typically, it says that they're only appointed until the next annual meeting, and then there's an election for that spot, but it really does depend on what your bylaws say. Question 14, if we don't meet quorum, let's see, I already got that one. Okay, question 15, monsoons continue to damage the retaining walls of the wash that borders 4 homes. This has resulted in spot treatment in the past, but seems now to be drastically worsening, requiring a better solution. The engineer cost is approximately $10,000, not to mention construction. Will we require member approval before spending this money? Thank you. Okay, so we've got retaining walls on the wash that borders only 4 homes. So I have to know more about, how these walls are treated. Are they, walls that we have mutual, like let's say the owner and the association has maintenance responsibilities? And I don't know if the damage is due to a lack of maintenance, by the association per se on this greenbelt or whatever wash that is adjacent to these homes. So there's kind of some factors here that I don't know the answer on. I'm leaning to say though that because, there's a drainage issue there and it's coming from the wash and likely the association has responsibility for the wash, that this is going to be an association expense and you're going to need to fix that drainage problem so that even if you rebuild the wall, it doesn't, continue to happen in the future. And so, do we need member approval before we spend 10,000 on this? It just depends. You probably need to have your attorney weigh in as to whether this is an association expense, number one. I would also look to see if there's an expenditure cap in your bylaws or your articles, maybe even your CC&Rs, that any expense over X amount of dollars, requires a vote of the membership. If it doesn't, then the board likely has the authority to do this. But again, check in with your attorney because you want to make sure that this isn't an expense that, should be charged to a third party if the wash is owned by a third party, or maybe if the owners did something that contributed to the damage to the wall, and they may have some responsibility to pay for this as well. Okay, question 16. How dangerous is it to not be in compliance with the Fair Housing Statement of Compliance, certifying a person living in a home is 55 plus? Arizona law states that the HOA must survey homeowners every 2 years. Okay, so this is kind of a sticky wicket. So if you're a 55 and over community, yes, you really should be doing a survey at least every 2 years to make sure that at least one occupant of every lot or unit is age 55 or over. And every CC&Rs are different, so you may only need to have 80%. It may be higher. I don't know what your CC&Rs say. State and federal law does require for you to keep your 55 and over status. It does require you to have at least 80% of the lots or units to have one owner or occupant, excuse me, that is 55 or over. Some associations, instead of doing a survey or a census every 2 years, what they're doing is they're updating the records, annually. Anytime a new owner moves in, they're asking for proof of verification. And so, they feel that that might be enough. It's probably not, because people pass away, people move, there's new rentals coming in and out. So we really do recommend that you comply with the law and do that survey at least once every 2 years. Okay, next question. Is there any recourse for the board when the management company gets a bid and pays for services that were not requested by the board? Really, the board should be talking with the manager and the management company and say, we didn't authorize this. This is not an expense that, we authorize you to pay. Look at your management contract. Maybe you have some recourse against the management company for doing this. I mean, I guess the question is, why did the management company do this? Were they doing it because, the board should be doing it and you just weren't doing it? Like, let's say it's I don't know, maybe there's a piece of equipment in your tot lot and there's a sharp edge on it and it's just a safety thing. The management company just checked a box and got it done for you quickly because it was a health and safety issue. I'm less worried about that. I think that's fine that the management company did that, but maybe it's a bigger expenditure. Like they authorized the tree trimming, $25,000, and the board didn't authorize that. So I need to know more about how much it was, why the management company did it, what the motivations were, what the bid was for. Did they get, 3 bids? Is it a reasonable cost that was paid? Um, you know, why wasn't the board consulted? And I would look at all the facts and then make a decision as to, okay, is this something that we're going to have to pursue the management company for? Is this something that's going to destroy our relationship where we're going to terminate the management company? Or is this something where we're just going to better communicate with the management company that we didn't like how this went down, but we understand why they did it? Okay, next question, number 18. Can you repeat what you said about the articles trump the bylaws? But then you said to follow the bylaws. Okay, yes, I will. So I will, under Arizona law, there's a hierarchy of documents. And the hierarchy is that the CC&Rs are at the top, the articles are second, the bylaws are third, and the rules or architectural guidelines are going to be fourth. So sometimes in that hierarchy, the documents conflict. So for example, let's say that the articles say that there should only be a 3-member board, and the bylaws say that there should be a 7-member board. You go back to the hierarchy that we talked about, and the articles trump the bylaws. So you would follow what the articles say. So I'm not sure why I don't believe that I said you follow the bylaws. You always follow whoever's higher in the hierarchy. So again, the hierarchy is CC&Rs, articles, bylaws, rules, architectural guidelines are kind of on the same level. So if there is a discrepancy in the documents, you go by who's higher in the hierarchy. Question number 19, and it looks like we have a total of 26 questions, so we're moving right along. Can you address who can speak, make motions, and vote in an annual meeting of the members? It was my understanding that all attending could vote on minutes, request amendments and corrections, but some board members believe even at the annual meeting, only board members vote with the exception of the election of officers. So really good question. So At an annual meeting, typically owners should be allowed to have a comment period. This is the owners meeting. Association boards should give owners an opportunity to comment. Typically, we do that while the ballots are being counted so that we're efficient with our time. So they open up the homeowner forum after the election closes and the inspectors of election are counting the ballots, maybe with the attorney, and then we let the homeowners have their comment period. So homeowners can talk during the annual meeting, during that homeowner comment period. Homeowners, typically the board runs the annual meeting, just so you know. So the president opens it, establishes a quorum. The first item on the agenda is typically approval of last year's annual meeting minutes. You need a motion from the audience, a second from the audience. There could be discussion, and anyone in the audience or the board could make a comment, and then the audience approves or disapproves last year's meeting minutes. Obviously the attendees, whether they're in person or by absentee ballot, they can vote on the approval of the minutes, they vote on the election of the directors, and you have an opportunity to say things in the comment period. Some boards allow for questions to be asked as like the president gives a report or the treasurer or the manager's report. It's really up to the board that they structure how that meeting is run. Okay, we shared with you again a cheat sheet on the annual meetings previously in this presentation, so I hope that you use that to help you. Okay, next question. How does the open meeting rule pertain to board discussion by email, then voting by email, or to special meetings versus regular board meetings? Okay, so the open meeting law requires that anytime a quorum of the board is meeting to discuss association business, it must be an open board meeting. Okay, so if you're having a special meeting of the board or a regular meeting of the board, you still have to give 48 hours notice to the membership of the special meeting of the board or the regular board meeting, and owners should be allowed to attend, participate, or listen. Okay, if your board is making decisions by email, be really careful on that, because again, the intent of the law is to have all decisions and discussion by the board during an open board meeting. Again, really the only time you can use email, and we talked about this earlier in the presentation, is to share information but not discuss it. Like, here are 3 bids for the tree trimming. We will discuss this at the meeting next week. Here is the board packet. We will discuss this at the board meeting. Can everybody meet the first Thursday of the month to do a walkthrough of the property, and then having people respond on that? That's okay, that are board members. But let's fire the management company. Let's talk about how the landscaper isn't doing a good job. All that should not be done by email. That needs to be done in the open board meeting. One suggestion would be is if you have an emergency situation where the board has no alternative but to make a decision quickly, you can't wait 48 hours. They can either meet in person or they can make the decision by email. And remember the paper trail on that. You need to have minutes, or you need to share the emails at the next regularly scheduled open board meeting as to why there was an emergency and what was decided. Okay, next question, which is question 21. What options does the board have when another board member does not fulfill their fiduciary duties as a board member and continually violates the governing documents? So we have a really good blog on this topic. It's called Dysfunction Among Board Members that we're sharing with you. Our website has a lot of great information on this too. You can, an option would be, number 1, you can remove that board member from office. So there's a procedure under Arizona law to remove directors from office. You can look at our cheat sheet. It's our top 10 cheat sheet. It's number 6 on the top 10 cheat sheet. There's a whole procedure you have to follow. So you can remove the director from office. You can have all the board adopt a code of conduct so that, if the board member is not living up to their fiduciary responsibilities, we can say that they're violating the code of conduct. You can ask that person to resign, verbally say at a meeting, we don't feel that you are living up to your fiduciary responsibilities. We are asking you to resign, and then have a piece of paper ready so that if they say they will, you get them to sign it. So there's no resignation remorse, which we've seen in the past. You want to be careful on that. Get them to sign it right then and there. You can, I mean, it doesn't make sense to sue this board member because it's like suing yourself, as a board suing a board member. The insurance company is going to defend that one board member you're suing. So that doesn't make sense. So really your best options are going to be to call out that person in a board meeting regarding their failure to, abide by their fiduciary responsibilities, ask them to resign, have that piece of paper right there handy. Run good candidates against them at the next annual meeting if you choose not to, do a removal petition to remove that person from office. And it's okay to document this in the meeting, ask this person to be better, do better going forward. You don't want to set the board up to be, sued, but hopefully a majority of the board is making good decisions. So it's just this one person that's not carrying their weight. Next question, number 22. If a quorum of a board member exchanges texts, is that considered a board meeting? And must it be shared with all in the HOA? Ooh, good question. So yes, this would be just like an email. The board should not be discussing association business. A quorum of the board should not be discussing association business via text. Now, a caveat I want to say is for email and text, if it's less than a quorum discussing association business, that is okay under the law. That's a loophole. If it's a quorum doing this, it's not okay, and it needs to be done in the open board meeting. Now, again, we've got that emergency exception, which we've talked about now 2 or 3 times in this session. Okay, next question. If our CC&Rs don't discuss fines for a violation of CC&Rs and provide a fine schedule, can our board impose fines under Arizona law? So great question. Yes, you can. The Condominium Act and the Planned Communities Act allow for associations to boards to levy fines against an owner for a violation of the CC&Rs, bylaws, and rules of your association. The fine just has to be reasonable, and you have to give the owner notice and an opportunity to be heard. So you do not have to have a fine schedule. Now, there was some confusion on this a couple of years ago because there was a case that was decided that he said that associations needed to have a written fine policy. Well, that case was later depublished. Is it a good idea? Possibly. Some associations really like it because it outlines, what the remedies are if we have a violation. We're notifying everybody this is, what the consequences are, and maybe that's a deterrent for people to behave badly if they see that on the fine policy. Also, it doesn't give a lot of discretion because to the board, it just says first offense, second offense, third offense. I mean, there's pros and cons for the fine policy either way. But the bottom line is you are not required under Arizona law. It does not say that in the statute that you have to have a fine policy. And the case that said that in Arizona was depublished, which means that it's no longer no valid law. Okay, next question, number 24. Our president and HOA manager said annual meeting is only going to be an announcement of board members only. Can they do that? It's scheduled for 30 minutes only. This seems like a level of dysfunction in your community. So that's really not how the annual meeting should be run. Okay, A, you have to approve last year's annual meeting minutes. B, this should be the time to give a report about what's been going on in your association. And C, obviously the main purpose of the annual meeting is to elect directors, no question. But the annual meeting is, like I said previously, it's a time for the board to shine. It's a time for the board to update the members as to what's been going on, whether it's good things, bad things, challenges, whatever. And you really owe it to your members to do that. So, can I say that's against the law? No. I mean, I'd like to see your bylaws because sometimes the bylaws have an agenda that you have to follow for your annual meeting. And if that's the case, your association should be following that. But it just shows to me that there is something going on there, that there's a problem on that board. I don't understand why they would just do that for the annual meeting. There's a level of dysfunction there that concerns me. Okay, last 3 questions. When we update our CC&Rs, will all of the amendments be in the new CC&Rs? So yes, depends on how you structure it. Sometimes we do an amendment where we just call it like the first amendment to the CC&Rs, and we just list what the amendments are, what the changes are to the few sections that have been changed. And then there's two separate documents. There's the original CC&Rs and then the first amended CC&Rs. And you need to look at both documents to see what the changes are. Other times, when we pass the amendments, we pass them as amended and restated CC&Rs, and that means that everything is included in one document. So it just really depends on how you structure the amendment. Last two questions: are many associations using DocuSign or similar methods to deliver ballots for signature? So great question. I would say that, a very small minority, like maybe 5% of our clients, are using electronic voting with like an electronic voting company like HOA Vote Now is one that comes to mind. So very few associations have converted to totally electronic voting using a company to manage, the voting. But a lot of associations are using different means to accept ballots, like they're accepting ballots by fax, they're accepting ballots by email, they're accepting ballots in ways that are different from, maybe the way we did it 10 years ago. So using DocuSign for ballots for signature, like I said, very few are doing that, but it is definitely the wave of the future. And the associations that have converted absolutely love it. And some barriers to converting on it are that some owners, have technological difficulties and maybe they don't even have a computer. So requiring them to vote, electronically in this manner would be a hardship to them. The way around that is that you give owners who want a ballot an opportunity to have one mailed to them, and you just put that right in the notice. Okay, next question. Can members of an association make motions at an annual meeting other than approve minutes and vote for the board? Or do they have to come in advance in the form of a resolution? Okay, so great question. So your annual meeting, we've kind of already gone over what the different topics are that are typically discussed, but can members make motions? No, they really can't, other than approving last year's meeting minutes and seconding it. Members can make comments about, how they feel things are being run or whatever. But like, for example, a member couldn't just stand up and say, I make a motion to amend section 3.1 of the bylaws to say this. That's not an appropriate motion for an annual meeting. So to answer your question, I'm sorry if I didn't fully answer that when you asked the first part of this, but there are limitations as to what owners can do at the annual meeting, and that would definitely be one of them. Thank you so much for all of you for being here today for class number 2 of our 2022 Virtual HOA Condo Academy. We're going to be meeting every month in 2022 with the Virtual HOA Academy, and it's always going to be the same time. So it's the third Tuesday of the month at the same time. And we will be, continuing on with cutting edge topics throughout the rest of 2022. I'd like to just take this time again to thank the neighborhood services departments from the cities of Avondale, Chandler, Glendale, Goodyear, Mesa, Peoria, Phoenix, Scottsdale, Surprise, and Tempe for their teamwork and continued partnership with our firm, the Mulcahy Law Firm, for putting together these amazing virtual classes. We have been able to provide free education to over 50,000 people, 50,000 views we've had of these classes to date. And you can tell by the attendance today, we had a record number of people here today, probably the highest attendance I think we've had since the pandemic was in really full swing. So happy to have you here today. So we'll be back again on the third Tuesday of the month on March 15th for class number 3 of our 2022 Virtual HOA Condo Academy. And we're going to talk about how to run effective board meetings and annual meetings. And I can tell those are hot topics because we had a lot of questions there. So I'm going to be talking to you from the trenches, 25 years experience doing board meetings and annual meetings. I'm going to tell you some good stories about things that have happened, some mistakes that I've seen happen at annual meetings, and I'm going to give you suggestions on how to comply with the law and handle any problems that you're having with either regular board meetings or annual meetings. So I hope to see you at any one of these upcoming free virtual teaching opportunities. I wish you all the best. I hope you have a great rest of the week, and I hope to see you again soon. Take care, everybody. Bye.